Good afternoon, friends. And once you know that Professor Dr. T.R. Subramanya, the Dean of CMR University School of Legal Studies, Bengaluru, is there, you have perspectives, especially on the international arena. And that is why we had requested him to share his knowledge once we keep on discussing on the social media regarding the International Court of Justice. And as such, he has acceded to our request and he was sharing his knowledge on International Court of Justice in the 21st century, challenges, opportunities, and relevance. We are so glad that he has accepted our invite, and over to you, sir.
Yeah. Very good afternoon to Mr. Vikas and your team and all the learned listeners. Now, today we'll be taking up something relating to the working as well as the role which is played by the International Court of Justice to the progressive development of international law. Now, most of you will be interested whether the International Court of Justice was established overnight. No, it was not established overnight because there were several things which I should mention in a few minutes. Now, the idea of having an international court of arbitration was mooted in the 16th century itself. There was a king, King Podibard of Bohemia, and King Podibard of Bohemia had a minister by name Sulle, and he was the one who, in the 16th century, canvassed or what we call as a court of arbitration. So, a court of arbitration to resolve the disputes between states peacefully. Now, that idea was there, and several other scholars as well, at a later stage, spoke about the establishment of something known as permanent court of arbitration at a later stage. But then these things, although were canvassed by writers and eminent scholars over the years, did not materialize. But then in the Congress of Vienna of 1815, soon after the defeat of Napoleon Bonaparte, many elderly statesmen spoke about this. They just wanted to have what we call as an organ to settle legal disputes only. But then most of it were heard peacefully. The writings were written by them, were read, and it went into oblivion. Now, the First World War started between 1914 and ended in the year 1918. And when the First World War came to an end, the great powers of the time, that is the state of United Kingdom as well as the state of England mainly and the state of France, wanted to have an institution which should be for purpose of establishing peace and security. And hence came the League of Nations. And the state of United States got involved in the drafting of it. But at a later stage, when President Wilson, Woodrow Wilson, when he submitted the League of Nations for the approval of the Senate of the state of United States disapproved it, and they said, we don't want to become parties to entangling alliances. However, the League continued. No, we are not interested in discussing the politics within the League of Nations. Now, the League of Nations, remember, in the Peace of Versailles, in Article 14, suggested it is the duty of the League Council and the responsibility of the League Council to frame rules for the purpose of establishing an international court. So, in order to this, by taking this into consideration, the League Council appointed a larger committee. And in this larger committee, there were two eminent men. And these men were, one is Mr. Root, and the other one happened to be Lord Fillmore. Mr. Root happened to be an American subject, American national, and Fillmore happened to be an British national. And the entire task of taking care of establishing a permanent court of international justice under the League of Nations was given to them. And it is these two scholars, and these two, remember, eminent people, respected everywhere, were the ones who suggested what we call as the statute for the establishment of a permanent court. Now, the same principles, what is being established under the League of Nations, is considered and it is continued under the International Court of Justice as well. Now, first and foremost, I will speak about the judges. Then I will speak about the composition. Then I will speak about the law that is being applied by them, and then who can be parties to the International Court of Justice, what exactly the issues with the International Court of Justice is empowered to take in. Then the last 30 minutes, I will speak to you the development of international law by the International Court of Justice. When we take up this matter under uh, the Court of Arbitration principles, that is under the Hague Rules of 1899 and 1907, they established what we call as a charter. And under this charter, it is the duty of the responsible states who intend to become a member of the Court of Arbitration to establish a national panel. So under the Court of Arbitration, indicated under the rules, the Hague Rules of 1899 and 1907, each state which is interested in becoming a party to the matters pertaining to arbitration is supposed to establish a national panel. And in this national panel, each state is empowered to, remember, appoint 4 persons, and 2 of which may belong to that state, to that individual state, and 2 of them must be outsiders, foreigners. Now, before nominating such people to the concerned arbitration court, the Court of Arbitration, as arbitrators, the concerned state will have consulted the entire academies who have devoted to the cause and development and promotion of international law. So, what kind of contribution the institutions in their own country have made, and who are these persons? And only by looking to this, their eminence, they can, remember, promote and nominate 2 persons. And the remaining 2, naturally, they can select from abroad, from a foreign country. That is how the panel was constituted. The other one is when the statute of the Permanent Court of International Court of Justice came in. Remember, some of the states did not want to become a member of the Court of Arbitration. When they are not interested to become a member of the Court of Arbitration, they are supposed to, remember, establish a panel. And this panel, remember, there shall be 4 members. Out of the 4 members, 2, not more than 2 of them, nationals of their own state, and 2 of them can be foreigners. And before the appointment is made to the statute of the Permanent Court of International Justice, remember, it is the duty of the concerned country to consult all the academic institutions, all the courts in their country, the talented people who have contributed for the growth of international law in their own country as well as in the world. Not more than 2 of them they can recommend, and the remaining 2 can be taken from the foreign countries as well. So remember, just like this, each state will have recommended 4 people, and under the League of Nations, for the first time, this is being constituted and the selection was made. Now, the same methodology is being adopted even to the International Court of Justice. So, when I speak about the International Court of Justice, the statute of the International Court of Justice is an integral part of the United Nations Charter. So, when we speak about the Charter of United Nations, the statute of the International Court of Justice becomes an integral part of the United Nations system. Now, for example, take it this way: you have the national panel. In the national panel, you have 4 people, and both the Security Council and the General Assembly will try to select. For the first time, they will sit separately and select 15 members. Take it this way: the one who gets the largest number of votes, or the 15 people who at one go may get selected, they get more than 50% of the votes, largest number of votes get selected as the judges International Court of Justice. Today, the strength of the International Court of Justice is 15. So if they are selected at one go, then nothing remains, everything is fine, everything is okay. Now, the second thing is, suppose, for example, the Security Council and the General Assembly sit together. When they sit together, they were able to get only 13 people with majority votes. And the remaining 2 are to be selected. And in order to select the remaining 2, both of them sit separately for the second time. And when they sit separately, remember, nobody gets elected. So at that time, remember, both the Security Council and the General Assembly will sit together, not separately. And when they sit, remember, the Security Council as well as General Assembly is represented by three plus three people. Three from the General Assembly, three from the Security Council. These six people, remember, try to elect the remaining two judges who did not get the majority to become judges of the International Court of Justice. So at that time, remember, one of them gets majority. Because the Security Council and the General Assembly will be considering only those names who are in the list, who have, remember, taken the nearly majority votes. From there, they will select one person or two persons. If they get selected, the matter gets over. Suppose, for example, when even after meeting the Security Council and General Assembly together, if none of them they are in a position to get majority, if they are not able to recommend the last person, the 15th man, then the judges who are already selected will select the 15th man. So there are 14 of them who are selected already. They will select the 15th man. And when they select the 15th man, remember, the one who gets the majority number of votes from the list which is already there with them, and in the list which is being submitted to them, which is being considered for the selection of other judges, they will select the person who gets the largest number of votes. Suppose, for example, there they are divided. And when they are divided, remember, the judge who is senior in age or the president of the World Court who is selected as the president of the court will have a casting vote. That is how, remember, the 15th man is selected. So if the strength of the International Court of Justice, remember, is 15. These 15 judges are elected for a period of 9 years. And remember, you may ask me what exactly are the qualifications for the Judges International Court of Justice. Now, the first qualification that is being pointed out is they are of a high moral character. Remember, they are be persons of high moral character. The second one is, which is being put in Article 9 of the Statute of the World Court, they should represent in the main forms of civilization and the principal legal systems of the world. They should represent the main forms of civilization and the principal legal system of the world. Now, the other one is they should have the competence to become judges, highest office of judiciary in their own country. Suppose, for example, if an Indian is appointed or his name is considered by this authority, that is the Security Council and General Assembly, this person should have the capacity and ability and the qualifications to hold the highest judicial office in his own country. That is what is being indicated there. So remember, judges in International Court of Justice hold office, as I mentioned, for 9 years. There is no age of retirement. Remember, death can take place when they are in office. In the event of death for the remaining term, remember, judges can be appointed for this purpose, for their place. For example, when Nagendra Singh, Justice Nagendra Singh, when he was the president of the World Court, he passed away. And remember, for the remaining term, another judge from India was appointed. Another judge was appointed as the president of the World Court. Now, these are certain things which are to be remembered by every one of us. Now, the other important factor is, now judges, when we are appointed and they are supposed to hear the case, there is a provision for an ad hoc judge. Now, you may be interested to know what is this ad hoc judge. When I speak about an ad hoc judge, now ad hoc judge is a judge who is appointed to hear and to write a judgment only in a particular case. For example, take it this way. There is a dispute between India and Portugal, which you had. And in the event of a dispute between India and Portugal, in order to decide the dispute, both the countries, if they don't have a judge, can appoint an ad hoc judge. Suppose, for example, when the case goes to the International Court of Justice to be heard, there is no judge of India or no judge of the state of Portugal in the ICJ. At that time, both of them, only for that case, only for that purpose, can appoint an ad hoc judge, and they go only for that decision for the purpose of hearing. Now, many scholars in the area of international law question this: what is this ad hoc judge? If ad hoc judge is appointed to the court, then what role is there for the agent or the counselor? See, when the case is heard through a person who is appointed as an agent, a lawyer from that country. And then what is left to him? Now, the International Court of Justice gave a beautiful answer that the International Court of Justice should be in a position to listen to the parties to the disputes from both sides. And they should be in a position to know the nitty-gritty issues of the dispute. Only when they know the complicated issues of the dispute from both sides, it will be in a position to, remember, help them to write the judgment impartially. That is why ad hoc judges are appointed. Now, ad hoc judges, when they are appointed, they are paid out of the funds of the court. For example, take it this way: in the right of passage of Indian territory, the state of India was represented as an ad hoc judge by Mr. M.C. Chagla, Muhammad Ali Karim Chagla. He was the youngest Chief Justice of India appointed by the British, and he was sworn in on 15th of August 1947 as the Chief Justice of the Bombay High Court. Now, this person goes there and he serves as the ad hoc judge, and the remuneration was paid out of the funds of the court for him. Every benefit he is allowed to get. Now, the other point that is being spoken is who there are other things. Who can be a party to the statute before the court of law? Now, before I speak about the parties to the statute of the World Court, one important thing which you should remember is in the International Court of Justice, who are parties? The first one is all the members of the United Nations who are parties to the statute of the World Court are parties before the court. They can take any dispute before the court of law for purpose of adjudication. So, the event of a dispute, all members of the United Nations naturally are parties to the statute of the World Court. They can go and get redressed and resolve their disputes, if any. Now, the second thing is non-members of the United Nations. They are not members of the United Nations. But then these non-members of the United Nations intend to keep a continuous association with the statute of the court. Now, they want to keep an association with the statute of the court because they want their disputes, major disputes, to be settled by the International Court of Justice. So, in such cases, remember, the expenses of the court will naturally be decided by a decision of the General Assembly based on the recommendation of the Security Council. Now, there will be a third group. Third group is this: that is, the non-members who, in a particular dispute, intend to go to the ICJ and the case to be decided by the ICJ. For example, there is a non-member of the United Nations who, in a particular case, wants to make use of the International Court of Justice. And at that time, the International Court of Justice will take up the matter. So, in the third case, naturally, the third point, it is the duty of the concerned state which seeks, remember, the help from the International Court of Justice for a judicial opinion, must give it in writing that in the event of a decision, the decision of the International Court of Justice will be executed by it to its logical conclusion. That is the fundamental point that is being harped upon. So, you should give an undertaking. When the decision is given by the ICJ, it will be enforced by the concerned parties to the dispute. Now, you may ask me, what is the difference between the second and the third? The second one is they want to keep an association with the court, but they are not members of the United Nations. Now, the point at issue, for example, the state of Switzerland was not a member of the United Nations earlier. Remember, wanted to seek the help of the statute of the court for the redressal of the problem. Now, the state of Switzerland admitted under this category in the year 1947. And there was another European state by name Liechtenstein, which was again wanted to make use of the statute of the court, which was taken in the year 1952. They were making use of it because the charge will be fixed only by the Security Council and addition of the recommendation of Security Council and addition of the General Assembly. Now, the third issue is if they are non-members, they are in a particular issue, they go before the International Court of Justice and give in it writing. In the event of a decision, we will carry out and we will remember implement the decision of the ICJ, and expenses that are incurred will be decided by the International Court of Justice itself. Now, the other important developments which I should speak to you happen to be now Article 34. Under Article 34 of the Statute of the World Court, only states and states only can become parties to the before the International Court of Justice. The point at issue is, can international organizations can become? The international organizations can become, remember, only to help the court in supplying the material. And for international organizations, remember, there is another type of opinion which is known as the advisory opinion. So under the existing rules of international law, only states and states only can become parties before the International Court of Justice. Then international organizations, for example, World Health Organization, Food and Health Organization, and you have maybe about hundreds of them. Remember, their case, if they have a legal dispute, they can go before the ICJ through the Secretary General of the United Nations or through the General Assembly of the United Nations, and the case will be heard and the case will be decided by the ICJ because there are legal questions that are being involved. Remember, strictly speaking, in advisory opinions, there are no parties, and it is only an opinion which is being given. All the international institutions or some of the institutions may be asked by the ICJ to give some material and to help to develop and render a beautiful judgment. This can be done. So international organizations can only go before the court and submit the material which is asked, which is sought by the International Court of Justice. Beyond that, they don't have any locus standi. That is how this is being indicated. Now, furthermore, there are many issues that is being discussed under Article 36. Now, what is this Article 36? Now, a state, remember, while becoming a party, it may give an undertaking that it will accept the jurisdiction of the World Court. Now, before that, I just intend to speak to you something relating to the existing Charter of United Nations, the charter which is in force, and the international conventions which are in force, and the bilateral conventions, the multilateral conventions, and the trilateral conventions, or the other conventions of a different nature which are adopted by parties. Now, remember, if you look to the Charter of United Nations, or if you look to or read the Convention of the Law of the Sea, or the convention, many other narcotics convention, in all these conventions, remember, you have a provision. In the event of a dispute between the parties, the matter shall be referred to the International Court of Justice, or the matter may be referred to, which is the optional clause. You may go to the International Court of Justice. But there are instances this optional clause may become a compulsory. That is where the International Court of Justice exercises jurisdiction on compulsory basis. For example, take it this way, there are thousands of treaties today. At least 150 to 300 treaties are multilateral treaties, to which all the states of the United Nations are parties to it, barring one or two. In these treaties, there is a provision. In the event of a legal dispute, the matter must be referred to the International Court of Justice. So if the word shall is used, remember, all matters has to be decided by the International Court of Justice, and it may be on different subjects. As I mentioned to you, on narcotic drugs, on law of the sea, on law of the air, on law of space, on education and cultural rights, in the area of human rights, in the area of torture, degrading, inhuman treatment, many of them, where the International Court of Justice, remember, gets the power of jurisdiction to hear the case. One. Now, the second one is there are other treaties as well. And in other treaties of a different type, for example, signed between the parties or between the regions. For example, in Europe, you have the regional cooperation and you have the European treaties. And simultaneously, you have the OECD treaties. Simultaneously, you have the Latin American treaties for that region. And here you have the Middle Eastern organization. On all of them at the regional level have certain treaties, and they may prefer that in the event of an international dispute related to that treaty, the matter must be heard by that treaty. But there are some scholars, they may say, the jurisdiction which is optional when it is written. Now, at times it may be considered as compulsory. So it may be a compulsory jurisdiction in the event of a legal dispute to refer the matter to the ICJ. So if it becomes a compulsory jurisdiction, remember, first and foremost, the International Court of Justice has to decide whether it has jurisdiction or not. And when it decides jurisdiction or not, remember, they will hear the case first. And having heard the case, they will say it has jurisdiction. I can tell you two important cases so that you understand the point better. There was a dispute between the state of Qatar as well as the state of Bahrain. And the state of Qatar as well as the state of Bahrain in the 1990s go before the International Court of Justice for the settlement of a dispute over Hawar Islands. And both of them were, both the states were claiming sovereignty over the Hawar Islands. One of them were saying it is part of the state of Qatar. And the other one was saying Bahrainis have gone there and established there and have been settled there. One fine morning, Qataris chased the Bahrainis and the problem came up and landed in the International Court of Justice. Now, when it landed before the International Court of Justice, one of the parties said, remember, the International Court of Justice has no jurisdiction to hear the case. Initially, they submitted a letter to accept the jurisdiction, and afterwards they said no. International Court of Justice said they have the power to hear the case and they can exercise jurisdiction in this case. For example, recently, I'm just telling you of the case of 2025 and the report which came in a few days ago. The International Court of Justice heard the case related to environment. The question is very simple, whether the International Court of Justice is empowered to hear in matters pertaining to climate change convention and issues that come thereunder. The International Court of Justice, having heard the case for the first time, stated that it has the jurisdiction and it can hear and it has the competence to hear, remember, issues relating to the climate change convention which was adopted in the year 2016. These are some of the things which come under the matter pertaining to jurisdiction. Now, the other important thing is what exactly the International Court of Justice has played for the development of international law. Now, when we take up this matter, the International Court of Justice over the years, remember, both International Court of Justice as well as its predecessor have played an immense role in developing international law, in refining international law, in promoting international law, and remember, in restoring order as well as justice in accordance with international law. That is, remember, the role of the International Court of Justice. Now, I just intend to speak to you. Now, when a case comes before the International Court of Justice, what exactly are the sources which is empowered to exercise? Article 38, paragraph 1 of the Statute of the World Court points out the International Court of Justice, while considering a case and during the course of hearing a case, is supposed to consider four sources. The first one is international treaties. It is empowered to refer all international treaties which are in force, which is a source of international law. Then the second one is international custom. And this international customs, remember, our evidence are considered as evidence for the purpose of considering a rule which is in existence or not, whether the rule should be respected or not. Now, the third one is general principle of law recognized by the civilized nations. This is C, international conventions, international customs. The third one is general principles of law recognized by the civilized nations. Now, you may ask me, what is this general principle of law recognized by civilized nations? When we take up this matter, there are certain principles in the municipal system, in the national legal system, which are commonly accepted by all legal systems. So, what is common is commonly accepted. and commonly enforced, and common judgments are given. Now, are there such principles? The basic question. There was a great professor by name Professor Harsh Lauterpath. Professor Harsh Lauterpath happened to be a VL professor of international law at the University of Cambridge. And this person of eminence later was, remember, appointed as the judge of the International Court of Justice. And this person, remember, when he was a professor of international law in the 1940s, wrote a beautiful book. And the name of the book is Private Law Sources and Analogies to International Law. And this professor was simply contending there are several sources which are considered as sources of international law. And all these sources, remember, have emanated from the civil law system or common law systems of the countries. Their origin is naturally on the common law system or the national legal system of a country. And it has to be respected by the international court as well. Now, the next question is, are there instances of this type? See, for example, there was a case which came before the Permanent Court of International Justice in 1928. And the name of the case happened to be Corsu Factory or Indemnity case. In the Corsu Factory or Indemnity case, the Permanent Court of International Justice, the predecessor to the International Court of Justice, accepted that what we call as the doctrine of res judicata is a principle of law recognized by the civilized nations. The principle of res judicata is accepted as a principle of law in all the municipal legal systems. Majority of the legal systems accept the principle of res judicata as a common law. And this is commonly accepted. It has to be accepted by the international community. And for the first time, the International Court of Justice, the Permanent Court in 1928, pointed out the principle of res judicata. We've been knowing when once a case is heard by a person, a judge, the same case cannot be heard on the same principle and the same principle of law by the same judge again. That is a common principle and which is accepted by the community of nations was the expression of the Permanent Court of International Justice. Similarly, there came another case in the year 1924. And the case of 1924 happened to be the Memoramatis Palestine concessions case. In the Memoramatis Palestine concessions case, the Permanent Court of International Justice pointed out the doctrine of subrogation is a general principle of law recognized by civilized nations. Under the Contract Act, you study what is subrogation. Remember, the person responsible should enter into the shoes of the loser. The loser should get the benefit, where the person who has done the harm must be in a position to step into its shoes and restore the damages. So the doctrine of subrogation is a general principle of law recognized by civilized nations, was expressed for the first time by the PCIJ. Then came what we call as the principle of good faith. The principle of good faith, remember, is commonly accepted, commonly practiced, commonly endorsed by all the legal systems of the world, and it is a general principle of law recognized by civilized nations. What is practiced in a municipal legal system should be accepted by the international court as well. Then there came what we call as another beautiful case, and another beautiful case happened to be relating to the Anglo-American practice. And in this case, the Anglo-American equitable rules. See, Anglo-American equitable rules which are being practiced by a particular state has to be, remember, accepted as a general principle of law recognized by civilized nations. Now, for example, the name of the case is diversion of water from River Meuse. So, in diversion of water from River Meuse in 1937, decided by the PCIJ, it said the Anglo-American equitable rules are general principles of law recognized by civilized nations. Remember, the impact of this was such. In the year 1969, there came another case before the International Court of Justice, and this is relating to the North Sea continental shelf cases. And in the North Sea continental shelf cases, remember, it was naturally a case between the adjacent coast. And in the adjacent coast, remember, there were three states, which I shall explain a little later. For the first time, it said the International Court of Justice repeated what was said in 1936 by the PCIJ. Remember, equitable rules of international law are to be applied even while sharing the resources and the territory of a particular state under the Convention of the Law of the Sea. See, such a beautiful thing. Now, thereafter, I just intend to speak to you on two important cases decided by the ICJ. Now, the first case that came up before the International Court of Justice happened to be what we call as the reparation for injuries served under the United Nations. I shall explain the facts of the case so that you understand the point better. See, in the reparation case, soon after the United Nations came in, the United Nations has employed several people for purpose of maintaining security in different parts of the world. So, for purpose of suspending the hostilities, they go to a particular place as truce negotiators. They go there as truce negotiators only to suspend the hostilities. So when they go there, remember, at times they were killed, they were wounded. In such cases, the case came up. Remember, can the United Nations maintain a cause of action? Now I shall tell you the facts of the case. There was a person by name Colonel Berndt. This Colonel Berndt happened to be a Swedish national. This Swedish national, remember, was given orders by the Secretary General of the United Nations to work in the new city of Jerusalem. And he was serving as a truce negotiator. He has gone there to suspend the hostilities between the rebels as well as the state. So when he was carrying on his activities, remember, he was killed by a gang of terrorists. When he was killed by a gang of terrorists, remember, the matter went to dizzy heights. And many people started questioning the United Nations itself. They asked, remember, first and foremost, the United Nations should pay compensation. And the reputation of the United Nations is lost, for which it should recover compensation from the persons who have responsible in committing such offenses. So at this juncture, remember, the Security Council submits some legal opinion, which was scrutinized, and the Secretary of the United Nations submits this opinion to the International Court of Justice to give an advisory opinion, because it is an advisory opinion which is allowed only for international organizations. The first one is, what are the questions that was put? Can the General Assembly maintain a cause of action in the event of a loss of its employee during the course of employment? Can the United Nations maintain a cause of action in the event of a loss of its employee during the course of employment? If the answer is yes, can the United Nations maintain a petition and a suit for damages for the United Nations for its reputation? Can the United Nations maintain a petition and a suit for the loss of its employees or the loss of the legal representatives? The legal representatives can step into the shoes of the person who was lost. Now, for all these things, remember, the International Court of Justice said yes, yes, yes. I shall just tell you the last paragraph of the judgment of the International Court of Justice. The International Court of Justice in the reparation case pointed out 50 states have come together collectively. These 50 states have come together collectively, remember, and when they have come to collectively together, they have accepted certain rules of international law. And they have accepted certain rules of international law. One of them is maintenance of international peace and security, which is the prime task. And while enforcing peace and security, if the employee is killed or is wounded or is maimed forever, remember, the United Nations should maintain a cause of action. And the legal representatives of the deceased are also entitled to file a suit and get the compensation from the person through the United Nations. But for the first time, the International Court of Justice pointed out United Nations has a personality of its own. If it has a personality of its own, it can sue as well as be sued in its own name. United Nations is a person in law. This was the decision of the International Court of Justice, remember, in the year 1949. Now, then comes another beautiful case, and another beautiful case happened to be a case which is known as the, remember, Anglo-Norwegian fisheries case. Now, what exactly are the facts in the Anglo-Norwegian fisheries case? Unless I tell the facts, you will not understand the principle. Remember, the coast of Norway is deeply indented. The coast of Norway is in curvature form or in zigzag form. It is not man-made. It is geography, geology, and morphology. It is not man-made because of geological factors, because of morphological factors. Remember, these things, remember, have come in, and the coast of Norway was deeply indented. When the coast is in a curvature form, it is just not possible to adopt what we call as the low water mark method there. Low water mark, suppose, for example, if the coast is like this, how you adopt the low water mark method? So to avoid this, in the year 1937, the King of Norway adopted what we call as the box method. In the box method, remember, he has selected 37 points. And these 37 points may be rocks, maybe fissures, maybe small islands, and maybe roadsteads. All these fissures, rocks, small islands, and roadsteads, remember, are attached. And all these, remember, what we call as the main areas, maybe rocks, fissures, small islands, and roadsteads, remember, are joined together by a line. And the area which is inward side of the shore is called as the internal waters. The area which is outside the line is called as the territorial sea. So that is how the Norwegian decree indicated by selecting 48 points in the coast of Norway. Now, by doing this, remember, naturally the state of Norway got 1,000 nautical miles extra. And when it got 1,000 nautical miles extra, remember, in its zone, internal waters, the state of England cried. It said, here is a case wherein the existing customary rule of international law is violated. Under the existing rule of customary international law, only the low water mark that has to be followed. And any other method other than the low water mark method to determine the what we call the territorial sea is void. It cannot be accepted by anybody. When there was no compromise, the matter was referred to the International Court of Justice. And before the International Court of Justice, remember, the state of Norway contended simply one important thing is, the first one is, if you look to the coast of Norway, it is not man-made. It is because of geography, geology, because of morphology, the things have come in. It is there for thousands of years. The coast of Norway is deeply indented. The second thing is the geographical features peculiar to the region. The second thing that I just wanted to say, economic factors which are peculiar to the region. The people of Norway exclusively live on the resources of sea. And these resources, the living resources, are marketed by the state of Norway. That is economic factors. And the court naturally should come to their rescue. The state of Great Britain pointed out it cannot be accepted because violates customary rule of international law. Under a customary rule of international law, low water mark is the only method. Other methods cannot be accepted. Now, for the first time, the International Court of Justice gave a judgment for the state of Norway. When it gave a judgment for the state of Norway, the decision was a revolutionary decision. It went to the extent of pointing out where the coast is in a zigzag manner, curvature, or in an intended manner. Naturally, remember, it can adopt the box method. And you should select certain points. And the points which are selected should not deviate from the general direction of the coast. If they deviate from the general direction of the coast, it cannot be accepted. And remember, this was considered as a revolutionary decision. Then, in the year 1949, there came another case, Corfu Channel case. Remember, in the Corfu Channel case, for the first time, the International Court of Justice defined what is an international channel. What is an international strait? Remember, there was the dispute between the state of Albania as well as the state of United Kingdom. Albania is a small state and it has a small economy. And remember, it had what we call as a channel, which was called as an international strait. In the channel, international strait, which is by the side of the coast of Albania, freedom of navigation is permitted during peacetime. If there is a war, the navigation or permission to pass or giving permission to take off the vessels is prohibited. Now, what has happened was, just listen. On 16th, oh sorry, this is on 14th of May 1946, four British vessels were passing through the Corfu Channel situated by the side of Albania. And they were passing through the coast of Albania. They were, remember, fired by the rocket batteries of the coast of Albania. So there are certain, what we call it, the sea guards. These sea guards fired those vessels through the coastal rocket batteries. And there was injury to the vessel. There was injury to the equipment. The state of Great Britain did not bother. 3 months later, remember, another four war vessels during peacetime were passing through the Corfu Channel. When they were passing through, remember, they were struck with the mines put by the state of Albania. And remember, when the mines were struck on the vessels got destroyed, and there was damage and injury to the people who were accompanying the ship. Now, the state of Great Britain got wild within 21 days. It came to the spot. Having come to the spot, remember, it swept away the mines which were put by the state of Albania without Albania's consent. So, after 21 days, it brought a naval ship, the state of Great Britain, in Her Majesty's name, come to the spot. And without the consent of Albania, it swept away the mines put by the state of Albania. Now, the state of Albania realized it is a small state then, and it cried in wilderness and goes to the Security Council. In the Security Council, the state of Great Britain blasted it. And when compromise was possible, the matter was referred to the International Court of Justice. And when the matter was referred to the International Court of Justice, the International Court of Justice laid down 2-3 guidelines. An international passage is created for purpose of providing passage to ships of all nations. And ships of all nations are supposed to undertake passage during peacetime. If remember, the passage is not free. If the passage is not free because of some trouble, it is the duty of the littoral state or the coastal state to warn the navigating vessels and close the passage. Instead of doing this, what have you done? You have fired from the coastal rocket batteries, first instance. In the second instance, you have put the mines. And afterwards, remember, mines were able to destroy the passing vessels which were no knowledge of it, and they got destroyed. And the state of Great Britain came there and swept away the mines. The point it issues, the state of Albania is at fault. And it is the duty of the state of Albania to pay compensation in instances of this type. That is the fundamental thing that is pointed out by the International Court of Justice. Now, the other one is it warned the state of Great Britain also. It said the state of Great Britain, because it is a permanent member of the Security Council, cannot take law into your own hands. Remember, without informing the General Assembly and the Security Council, how we can carry on the sweeping operations of the coast of Albania? If the mines are there, if you want to sweep it because you have some other vessels which are coming or following it, you should have brought it to the knowledge of the Security Council. Without informing the knowledge of the Security Council, you can't just do it. That is the point. Now, important thing is, I shall just quickly speak to you the contribution of the ICJ to the United Nations proper. Now, what has happened was, when the United Nations came in, there was East-West rivalry too much. When East-West rivalry was too much, remember, it was not possible for one nation, if it is a communist country, to get admitted as a member of the United Nations. And if it is one communist country, if you wanted to become a member of the United Nations, the American group would oppose. Similarly, one democratic country, if it wanted to become the member of the United Nations, the Russian group, Russia, Poland, Czechoslovakia, Latvia, Lithuania, all communist countries would oppose in the United Nations. In such a situation, Remember, it has become perennial. And in 1955, remember, the General Assembly was in a position to, along with the Security Council, was in a position to admit 16 states as members of the United Nations at one go. Because 8 of them were Democrats and 8 of them were communists. There was unanimity and they became members of the United Nations. Now, in such a situation, for the first time, the General Assembly asked a question, an advisory opinion from the International Court of Justice. While admitting member states to the United Nations, can the General Assembly consider any other matter or any other point other than what is indicated in Article 4 of the Charter? Article 4 of the Charter of the United Nations points out that, first and foremost, any person can become a member of the United Nations provided it is a state. And when it is a state, it should have a defined territory, defined population, and established government. And the fourth one is it should be in a position to carry out international relationship with the rest of the world. So the point is, other than any other criteria, the International Court of Justice pointed out the criteria are already stated in Article 4. Only those other criteria can be considered, other criteria cannot be considered. Now, second came in, there was another advisory opinion. Now, this advisory opinion, which was referred to the ICJ again from the General Assembly. Now, the question is very simple. Can the General Assembly, without the recommendation of the Security Council, admit a member to the United Nations? So, if you look to Article 4, it clearly states at the end, any member fulfilling the provisions cited above, that is, defined territory, population, government, and the capacity to enter into relationship, and practices and believes in peace, can be admitted to the United Nations based on the recommendation of the Security Council, based on the recommendation of the Security Council by a decision of the General Assembly. So, recommendation which is followed by a decision of the General Assembly is compulsory. The International Court of Justice simply pointed out recommendation of the Security Council for purpose of admission is a condition precedent, and it should be there. Without it, you cannot admit anybody. And if you want to reject, you can reject. You are entitled, but then recommendation of the Security Council has to come under the provisions of the Charter. Then only you take a decision, whatever. So this is the way it protected the Charter. Now, for example, there was another occasion happened to be an occasion where in the Security Council of the United Nations, all members will participate in the discussion. Having participated in the discussion, remember, they shout, and afterwards everything comes to a grand halt at the time of voting. At the time of voting, these members, some of them are permanent members, used to abstain from voting. They go to the library, they go to the refresher room, or they may go out, they may be sitting in some canteens there, and they want to abstain from voting. Now, this has become a disease, especially for the permanent members. If they don't want to support, they will participate in the discussion, speak, shout everything. At the time of voting, remember, they go out. Now, this matter again was referred to the International Court of Justice for an advisory opinion. The International Court of Justice pointed out, remember, abstention tantamounts to concurrence. If you abstain from voting, you are supporting the majority decision. That cannot be done. Because under Article 28 of the Charter of the United Nations, members of the Security Council are expected to be the headquarters, and they cannot go out of the headquarters. Even if a meeting is called by the Secretary General at 2 a.m. in the morning, they have to go, they have to attend, they have to participate, vote, and participate in the decision. Abstention tantamounts to concurrence happened to be another. Now, there is another case which was decided by the ICJ in 1962. Now, what is this decision? This is known as the certain expenses case. Now, what has happened was, since there was no unanimity, no decision was forthcoming from the Security Council. Now, what has happened was North Korea invaded South Korea, and the matter came up before the Security Council, and in the absence of Soviet Russia and Poland, a decision was taken, and a decision to constitute the emergency force, United Nations forces. And this United Nations forces has to go to the spot and went to the spot, and their duty is to suspend the hostilities, to remain the fighters where they were, not escalate. So they go there, and afterwards what has happened was the expenses are incurred. These expenses to maintain the forces, first and foremost, came before the General Assembly for approval. And the General Assembly approved it. When it approved, the matter was approved by the General Assembly. Remember, Soviet Russia put a question. And this question is very simple. It said, matters pertaining to international peace are to be discussed only by the Security Council. It cannot be discussed by the General Assembly. And the matter, when it went to the International Court of Justice heard. And having heard the case, it went through Article 24, Article 25, 26, 27, 28, all of them it went through. Having gone through, it went pointed out. The article under the Charter only says this much. The primary responsibility of maintaining peace and security is with the Security Council. The primary responsibility of maintaining peace and security is with the Security Council, but not the exclusive responsibility. Under Article 10 of the Charter of United Nations, Article 10 clearly points out the General Assembly is competent to discuss any matter. See, competent to discuss any matter within the scope of the Charter of United Nations. That's it. Primary responsibility is with the Security Council, but not with the exclusive responsibility. If the Security Council fails because of the veto system or some other problem, remember, some other organ, which is also appointed for the purpose of peace and maintaining peace and security, is empowered to look into the matter. See what contribution they have made. And people these days speak without the knowledge of United Nations so many things which cannot be accepted by anybody. Now, similarly, I just told you the North Sea continental shelf cases. See, North Sea continental shelf cases happen to be a dispute over a concave what we call as coast. Now, in the North Sea, there are three states. First one happened to be the state of Netherlands. And after the state of Netherlands, adjacent to it, you have the state of Germany. And adjacent to the state of Germany, you have what we call as the state of Denmark. So what has happened was somewhere in the middle of the North Sea, scientists have pointed out there is huge oil. And when this huge oil and the discovery of oil was made, remember, all the three adjacent states wanted to, explore and exploit these resources. And all the three states started saying that area wherein the oil is found is ours. And they were in a position to say, remember, the continental shelf speaks about the sedimentary rock and the sedimentary culture. It is an extension of the landmass beneath the seabed and subsoil up to the distance of 200 nautical miles. So it is within the 200 nautical miles, and it is the culture of the mud and the culture of the rock is the same as is ours. Norway started saying, Germany started saying this. Germany went on saying we are the largest states, and claim is ours, not yours. And ultimately, all the three states submit separate agreements. One between Norway and Germany, and the other one is between Holland and Germany. The matter was referred to the International Court of Justice. The International Court of Justice, having heard the case, wherever, remember, a dispute comes between adjacent states, naturally they have to apply the equitable principles of law. And it warned and said the natural prolongation of a coast, natural prolongation of a coast must go to that coast because it is the natural prolongation of its coast, its sediment culture, etc., etc. Where it is not possible to come to an understanding, remember, they should adjust the problem by entering into an agreement. So in that area wherein you have huge oil, where all the three are claiming, and in certain areas where a title cannot be approved, you come to a regime of joint jurisdiction. And if it is not possible by settlement, by treaty, come to a regime of joint jurisdiction and share the resources equitably. Everyone should get it. That is what the International Court of Justice delivered in this. After the North Sea continental cases, remember, plenty of cases came up on this subject. Albania versus Malta, Libya versus Malta, on sharing their continental shelf, and all of them applied equitable principles. Now, I just intend to speak to you three cases before I wind up. Now, one case happened to be relating to the nuclear test cases. Now, nuclear test cases relating to something relating to an agreement which was decided by the International Court of Justice in the year 1974. State of New Zealand and the state of Australia go before the International Court of Justice and request the World Court to stop the explosion of nuclear weapons in the Pacific. And they go to the extent of pointing out, we have come here before this court. Australia and New Zealand, they were saying before the court, we have come here as the common friends of mankind. We represent the whole world. We represent the civilization because of the hydro nuclear aspects which are covered in this, the entire coast is being destroyed, and the concerned state of France should not be allowed to explore these weapons was their contention. Now, what has happened about the state of Norway? The International Court of Justice gave a notice to the state of France. The state of France appeared before the International Court of Justice. Having appeared before the International Court of Justice, remember, it said in future we'll stop. And it stopped. And afterwards, no explosion has taken place. This was 1974. Now, remember, in the year 1990, the state of New Zealand again goes to the court of law and asking the court, remember, to conduct an EIA by the state of France before it explodes another nuclear weapon in the zone. Now, what is this? Remember, they came to know that the state of France is going to explode another nuclear weapon, thermonuclear weapon. And before its explosion in the Pacific coast, it has to conduct an EIA. Direct them to conduct an EIA. But the International Court of Justice, having heard the case, it said, remember, we don't have jurisdiction. They escaped. But then there were three judges, and these three judges gave a dissenting opinion. Always remember, the judges who write dissenting judgments will be thinking about the future and the shape of things which are likely to come in the future. And these judges, remember, Justice Veeramantri, one of them, from the state of Sri Lanka, and other two judges of different states, they went to the extent of finding out that you look to the laws which are adopted in the area of environment from 1972 to this date. And if you look to, for example, the Stockholm Conference on Human Environment 1972, and the other declarations which are adopted in 1982, then the Doctrine of Sustainable Development of 1985 onwards, and early notification which was adopted by the Atomic Energy Agency in 1987, and many other. All these Biological Diversity Convention which was adopted in 1992. I can speak hours together because of time, I'm just cutting short. Now, the International Court of Justice pointed out, they speak about the restoration and establishment of a rule of international law. And over the years, this has become a customary rule of international law. And coast is not for a purpose of threatening the people, harming the people, not for spreading radioactive waves. This is not allowed under any circumstances, which should be stopped. All the three, Justice Koroma and Justice Palmer. Palmer is the man who said this. Look to the jurisprudence that is developed after 1972. All of them, remember, go to the extent of speaking and just like rules which are in jus cogens of a nature. Then the other person, Justice Veeramantri, pointed out, remember, first and foremost, you have EIA. For example, in India, EIA came in after 1992. And International Court of Justice, for the first time, he said he should have EIA. Without EIA, what kind of, remember, experiment you are making? You should know what type of harm it is, who are going to be affected, what are the remedy, what precautions you have taken. Without doing all these things, how you can explode the nuclear weapons? Then the other judge, remember, Koroma, he was the one who was speaking, look to the, what we call the 1972 declaration, Stockholm Declaration. Look to the Rio Declaration. Look to the Biodiversity Convention of 1992. In all this, you find a common article, that is no harm rule. States have sovereign rights to do what they want. But then, this sovereign right cannot be exercised to the extent of harming another coast, another state, another person. If that is done, remember, it cannot be accepted in international law. And today, no harm rule is a customary rule of international law. Now, starting from the trial smelter arbitration case till this day, I can give you plenty of instances of this type. Now, the other case happened to be the pulp mill case. It was decided by the International Court of Justice in the year 2010. In the pulp mill case, remember the dispute between Uruguay and Argentina. The state of Uruguay, in the mouth of the river, wanted to have two pulp mills. When it wanted to have, remember, two pulp mills, the state of Argentina, because the river the river Uruguay divides the state of Argentina as well as the state of Uruguay. It is the Uruguay River. If these two pulp mills are going to be established, first is it will hamper the biodiversity. It will, remember, not be in a position to provide clean drinking water. And it will destroy the living resources of the sea. And extensive, costly timber and other things will, remember, go. It will disappear from the coast. And in the name of modernization, having pulp mills, all these things, it should not be allowed. Immediately, the International Court of Justice gave a notice to the state of Uruguay. The state of Uruguay appeared before the International Court of Justice. Having appeared before the International Court of Justice, remember, it said we will not be having pulp mills. We will see that environment is restored, environment is protected, come what may. All the obligations which are indicated right from 1972 convention till the protocols which are adopted in the Kyoto Protocol and other things, we will adopt and enforce. That is it gave it in writing before the ICJ. Now, the last case which I just wanted to harp upon happened to be the recent case which was delivered by the International Court of Justice on the Climate Change Convention. Now, this is an advisory opinion which was given by the International Court of Justice. Now, some of the states went to the International Court of Justice and they said, what exactly are the obligations? So at that time, the other group go and say that the International Court of Justice have no jurisdiction to listen to case of this type. So last year, in 25th, in the 2025, it gave the judgment pointing out, remember, International Court of Justice have inherent right to listen cases this type. If the International Court of Justice is not going to listen cases related to climate change, what else is left for that? What it can listen? Now, for the first time, it said it can listen. Then it went to the extent of analyzing the obligations under the Convention of Climate Change of 1916, because it came into force in 1916. All these are to be adhered, all are to be respected, and the states are supposed to take, remember, measures which should be effective. And remember, it was actually endorsing the primary principle of the Charter of United Nations. Remember, live, let live, and all of us live together peacefully for the restoration of international peace in a climate which is harmonious to nature. Thank you again. Yes.
So the way you speak spot on has always been quite fascinating, and it's all quite encouraging. Rather, I would say that there should be one session as to how you can speak such extempore despite the practice one cannot speak. And that too on a subject which is not spoken on routine. Now you find YouTube's, yours are always rare species, just like in a lighter way, they said like they are like dinosaurs which can only be respected. So since it was a very niche topic and you spoke extempore on such a good topic, it's quite surprising that there are no questions. And we are always indebted to you, and we will take from you. Thank you.
Any question if they have, they can ask.
One just question has come. Please elaborate on the removal of ICJ judges.
Yeah. Now, see, a judge who is appointed to the International Court of Justice cannot be removed. He is appointed for a period of 9 years. He can be removed on the reason of moral turpitude. And on this reason also, if he has to be removed, there should be a unanimous opinion of the other 8 judges. And one more thing, see, 5 judges are appointed every 3 years. Now, like the Rajya Sabha here. Now, 5 judges they are replaced by every 3 years, just like the election that is taking place, because there should be continuity of thought, the seniority. Men with experience and wisdom should be in a position to, remember, help the junior most judges to respect the tradition of the International Court of Justice in upholding in rules of international law. It has helped in promoting international law, defining international law, refining international law, and developing international law. I have given you a few cases how it developed international law over a period of time. There could have been more cases, but it is not possible unless it is a topic of a different independent topic.
Yes.
Yeah.
And why did Iran not approach the ICJ against the invasion of US or Ukraine did against the Russia?
See, the point is Iran is only a bit I will tell you because we don't want to indulge in politics. First and foremost, International Atomic Energy Agency rules. Now you have what we call as the Treaty of Non-Proliferation. Under the Treaty of Non-Proliferation of 1968, a state which has a nuclear know-how is not supposed to give the technology to the non-nuclear state. Simultaneously, a state which does not have the nuclear technology is not supposed to take the nuclear technology and the know-how from a state which has the nuclear technology. Here the state has violated, hard fact, because it has been receiving technology from all the states. That is why it will come to limelight and this court will say, don't come with these things before us. It is my opinion. It may be different also.
Yes.
Yeah.
Thank you, sir, for sharing your knowledge. As usual, we keep remaining indebted to you.
Yeah.
Not only for the fact that you have been sharing knowledge, but also for the speakers which come and share the knowledge. Ma'am Chha is also coming again on Saturday to explain the digital evidence. So stay connected, stay blessed. Those who are not subscribed to the channel of Beyond Law, they can always do that. Thank you.